Hello, everyone. I wish you a very happy new year to kick off. And thank you for tuning into another episode of the Art of Cybersecurity series by 7 Rules Cyber with me, Chirag Joshi. I'm your friendly neighborhood CISO trying to make sense of all the cyber madness that we see around us. And along this journey, we've had so many great conversations with excellent people from different walks of from professional lives when it concerns cybersecurity, things like journalism, entrepreneurship, leadership, and law, amongst others. So it's been a fascinating journey so far for the show, and I really appreciate all the support that we've had. Now, as we kick off 2024, I always say that cybersecurity is becoming more and more prominent from corporate boardrooms to living rooms, and we're seeing that demonstrated everywhere. But that also means that the way we think about cybersecurity needs to progressively evolve. We've established a long time back that this is not just a technical topic and it's not just for technical people. There's so much more to it. And something which is, I know, on top of a lot of CISOs' minds as well as on top of business executives' minds is the legal implications around cyber breaches and data breaches. And with that, I have someone who I'm really excited to get into a deeper conversation with, someone who I've had the good fortune of knowing for some time. And I think she brings a level of enthusiasm and insights to a really sometimes dry field, if I say so, of privacy and law. I don't find it dry, by the way. Some people might, but she brings a lot of enthusiasm around it, and I think that's much needed. And I want to formally introduce Georgia to the show, and then we'll get into some of the details. But Georgia Marwick, welcome to the Art of Cybersecurity. We are so delighted to have you join us.
Thank you so much, Chirag. It's a pleasure to be here. Very, very much looking forward to getting enthusiastic about cyber and law and privacy.
Oh, it's a lot of fun. It's a lot of fun. We're going to talk about lawsuits. We're going to talk about legal privileges. We're going to talk about defensible positions in cybersecurity. So much excitement. So, Georgia, firstly, if you could give an audience a little bit about your background, your experience, and what you're doing currently, we can start with that and then go into some of the topics.
Sounds great. So I am a lawyer, but that's almost a previous life now. I started out in a commercial law firm, a national firm, had a great time, worked a lot in the class action space, did a lot of commercial litigation, both in Western Australia and over East. I worked in almost every single court, superior court in Australia, I think, apart from obviously the High Court. Never quite got there. But now I'm working as a data privacy lead in the cyber risk and assurance group at CSO Group. So I've been here now for 6 months, and it's been really fascinating to pull together all of those little bits and pieces that you get with law, the legal fraternity, privacy, cyber, and sort of pulling that all together and going, how can we make this easier and better for organizations to understand the intersections between those three things, because it's difficult and it can be very overwhelming. So we're just trying to sort of educate business and individuals on how they can be better without having to, reinvent the wheel.
Oh, awesome. Awesome. And it's great that you kind of have had experience in all these different areas, which is what we want, right? I mean, more and more, like I said, cybersecurity is such a vast topic now, and it's one of the core risks to an organization, opportunity as well, but a core risk as well. So, it's no longer sufficient to kind of put it under an IT area somewhere and not worry about it and leave it to technologists. I mean, it's something that is on top of mind from directors to executives and the C-suite, and we're seeing regulators increasingly expecting that. So it's perfect. All right. So with that, Georgia, let's get into the conversation. And one of the first things I want to talk about, and I teased this early on, is lawsuits. And I spent a lot of my early professional career working in cybersecurity in the US before I moved to Australia. And lawsuits are fairly common in the US, as we know on a host of different things. When it comes to Australia, though, it's different. It's a different environment. But for cybersecurity now, we are starting to see class action lawsuits, put forward. And we've seen that, if I'm not mistaken, for both Optus and Medibank with regards to the material breaches that they suffered over the last few years. But I want to get into that with you with regards to it is, What do you make of these class action lawsuits? Have there been precedents of any successful class action lawsuits related to cybersecurity? And do you think it's going to become more and more common as we go, especially in the light of how digitally connected we are and how much of a target we are, as we know?
Yeah, look, I think it's a really interesting space. The class action regime in Australia has been growing significantly, and there has been a massive uptick in class actions over the past sort of decade or so. The types of class actions and the trends, there was a real focus on the financial services industry, predominantly because of the 2018 Financial Services Royal Commission. You saw a lot of securities class actions come out of that, and then also this consumer-centric class action, which is now what we're seeing with Medibank and Optus. And I think that people are starting to pay more attention to cyber and privacy. And with that, whenever there's sort of an excitement or an interest in the public domain, but also in policy and government, you will start to see quite a clear trend in class actions. They're profitable, they're good for law firms, they're good for funders, they're good for individuals. You know, the purpose of them is to take people who might only have claims of a few $1,000s, who would ordinarily not be able to go up against your Medibanks and your Optus. It's a bit too hard, it's too expensive, you know, it drags out. So this regime gives people the ability to take these big organizations to task on their, you know, arguably poor behavior, or, you know, whatever the case may be. So I think that it's already a trend. The fact that you saw, I think there were 4 competing class actions in Medibank, and I think 4 again in Optus. Now, since then, they have been consolidated, but they jumped on it. Law firms and plaintiffs alike just went, no, this is an issue. And the community attitudes in Australia to privacy, we know from the 2023 report, people care. They care about their data, they care about their information, they want to know it's secure, and they don't want it anywhere it shouldn't be.
Yeah. No, and I think that's an important point, is expectations are changing as well. And Georgia, are there any precedents of class action lawsuits that have been successful when it comes to kind of data breaches here in Australia that you're aware of?
Not really. Okay. No, not really in Australia. There was one in New South Wales in 2017. It was a very small action and it's settled. I think there is a bit of a problem in Australia. Well, I'll say in Australia because I'm not quite across the US class actions as much in this area, but one of the things that we're seeing is that it can be hard to, yes, there might be damage or loss for people, but the problem is trying to establish a cause of action or multiple causes of action. You know, we don't have an inherent right to privacy in Australia, and there is no individual cause of action under the Privacy Act at the Commonwealth level in Australia. So as an individual, I can't just go and sue Medibank. I don't have that right. So that is something that I think the law firms are trying to push their way through. So you see, for example, with Medibank, you know, their causes of action are varied. They're very wide ranging. You've got breaches of the Privacy Act and the APPs, Australian privacy principles, but then you've also got misleading and deceptive conduct, you know, breaches of contract, breach of confidence, you know, so they're really throwing everything that they have at it to sort of see what sticks, I think. And because these are the first ones, we don't know what's going to come of them. So they are really important, you know, they're going to set a very interesting precedent going forward. And I think once you've got an established causes of action that you can take in these situations, and then you've got you know, how you calculate that loss and damage, once that's been established, then it's open slather.
Yeah. I know it's a very, it could potentially, to your point, it's going to be a very important milestone for both law and cybersecurity here in Australia. So, you know, everybody's keenly watching this space. Do you have any insights, Georgia, on typically how long this could take, or by when do you think we could have some at least some initial observations on this?
Look, it's so hard to say. Class actions, you know, some of them run for a couple of years, some run for 5 or 6. I think
Right.
the
Right.
last time I read an analysis on class actions over the past 10 years, the average I think is about 40 odd months. So you're
Okay.
talking.
So it's just 3 to 4 years is
Yeah.
what you could expect. And then in terms of and you're right, like I'll be very interested to see what comes out of it in terms of the damages and what's actually on the hook for people, because it's going to be quite we've tried to do, and I always say, and we'll talk about this a bit more later, but defensible cyber programs require you to have good cyber risk management practices, which are part of enterprise risk management practices. And you need to be able to actually do this well. If you can quantify the risks and contextualize the threats, that's what makes it special, and that's what makes it so much stronger. And data points like this will really help, because data points like this make it real to people, as opposed to abstract studies sometimes, where it becomes hard to know what it really means for us. So we'll keep a keen eye on that, and hopefully as we get more progress on that front, have you back on to talk about that in a bit more detail, because I think that's going to be an exciting time. The point I also want to now talk about beyond class action lawsuits, and this is a very interesting one, and I found it very interesting because as a CISO, I've always worked very closely with legal and lawyers, and I know more and more CISOs and organizations understanding the importance of it. But legal professional privilege. Now, I understand to a degree what that is, but I can appreciate that a lot of audience may or may not know it. So maybe we start first with defining what is legal professional privilege. And the reason I bring that up is and you know this, Georgia, but a very interesting thing happened where Optus, after it suffered the cyber attack, engaged Deloitte to come in and help them, understand what went wrong, and they actually announced that as well publicly. Optus did that. They've engaged an external third party to come in and look at what went wrong, and see how they can, be addressing those root causes of the future. Fairly typical exercise, right, after a major breach. However, an interesting thing happened where they also tried to protect it. They also tried to protect that, applying legal privilege on that, so that report could not, be disclosed, the contents of the report rather. And the court decided that that wasn't sufficient. So obviously, with your legal background, and you are the expert here, I would be very interested to understand from your perspective, firstly, defining what is legal professional privilege, and where do you think this whole situation went wrong for Optus?
Yeah, look, that's really interesting. So to start off, legal professional privilege, in order to make a claim for it, you must be able to satisfy that the document or the communication, that its predominant purpose was to be used in legal advice or in litigation or anticipated litigation. So Optus, as I understand, made the claim of legal professional privilege for legal advice. Now, it must be the predominant purpose. So you can't have 3, 4, 5 different equally weighted purposes and still try and claim privilege. Historically, we've seen a lot of organizations, and I won't name them, but you can all look them up, that tend to copy in their legal counsel or an external firm just so that they've got the lawyer on the trail and say, well, no, I'm going to claim privilege. There was a lawyer on here. We were talking about all kinds of, commercially sensitive things and/or, something that they would like to protect and don't want to disclose. And people, I think, have gotten away with it for quite a long time, just this guise of legal professional privilege. But in actual fact, it is very strict. It is an obligation, or the onus in establishing it is borne on the person who is trying to claim it. So in this case, it was Optus. They were, required to establish that the privilege did apply or attach to these documents or to the report itself. And it wasn't just the report, but it's all of the, annexures and communications that go with it. You never just get, in those situations, just a neat little report. You've got lots of sort of different communications going backwards and forwards. You've got letters of engagement, all kinds of things. So yes, it's quite a narrow burden and a strict burden to meet, actually. So in Optus's case, they tried to argue that the purpose was purely for legal advice. And they did refer also to the idea that they were getting the Deloitte report to understand the root cause analysis, but so that they, in anticipation of litigation potentially, but also so that they could give legal advice based on the root cause of the breach. Now, the court held and we can talk about this a little bit more, but essentially the court determined that that just simply wasn't enough. And the substantial purpose was there. Yes, there was a substantial purpose of legal advice. They engaged an external law firm. The law firm then went to Deloitte and said, we need this analysis done. However, what I think Optus, and look, they made a couple of maybe missteps in this, but the key thing was that the CEO sort of announced through a media statement that Deloitte was going to be brought in, and they were going to do this root cause to understand what happened, how it happened, and how they can avoid it in the future. Now, that is not a dominant purpose of legal advice. That is a dominant purpose of a root cause analysis to establish what went wrong and what they can do to fix it. So it simply just wasn't enough. And putting that out to the world at large was one thing, and then it was referred to in some board resolutions. So they really didn't cover themselves in that respect. And it was just too many different purposes. So there's just simply no way that they'd be able to satisfy that dominant purpose. And it really does have to be the predominant purpose. And I think that that's really, important to hone in on, because you can get a bit, I suppose, particularly when it happens so quickly, you rush things and you go, oh gosh, we really need to get this sorted. We need to understand, we need to engage these people, and you can get lost in the chaos a little bit. So for me, I would have said, there's a bit of a carve out there. You do your root cause and go, what went wrong? And that's probably not going to be able to have legal professional privilege attached. And, that's just something that companies need to be aware of. But if you would like to go and get legal advice or a report done for the purposes of legal advice, be really clear and consistent in your messaging and the way that you're writing your terms of reference for whatever it is. You just take a breath would be my, non-legal advice. Just take a beat.
No, it's such a fascinating point though, because and that's really the key as far as I understood it, and you explained that really well, is your predominant purpose in this case was root cause analysis. And I think if you wanted to have legal privilege applied, you should have gone about this very differently in terms of your communications, in terms of your approach to it. But all of this also comes back to, and this is what I kept saying, like when I do consulting engagements, or when I am doing workshops and training, a big part of what I focus on is that preparation part of it. And far too often people have thought about data breach preparation as, the technical response, or even communications and media, and all of that is important, don't get me wrong. But the discussions with your legal team and having them at the table is so important as you frame these discussions and frame these approaches so that you're prepared for something like this. Because even a supposedly innocent statement, or or a statement which was not very informed, can come back to bite you, because in the heat of the moment you were trying to do the right thing maybe, and you're trying to kind of put out the right messages out so you give comfort to your affected people, but then you end up hurting the other objective that you had. So I think, to me, it boils down to preparation. And look, we are talking about large organizations here. These are not small and medium business enterprises who have a whole different issue. And if these large organizations struggle, imagine the problem that we have. And which is why I think it all comes back to preparation. And it's so important that people consult with their legal teams early and bring them at the table. And to your point, and in the past, maybe, people thought they were doing the right thing by just seeing the lawyers, and thinking that they're going to get privilege. But you brought out that, at least here in Australia, that's not gonna fly as this turns out. So a really important point, and again, emphasizing the importance of the legal cyber relationship that we've talked about so far. So thanks for weighing in on that one, Georgia. So now the other thing I want to talk about is generally the privacy landscape now we're seeing emerge in Australia. And a lot has changed and a lot can change materially over the next few years. So firstly, as far as my understanding is, we've seen the fines are now much bigger than they used to be. They used to be capped around 2 million odd, and now they are, there are different criterias, but they could be upwards of 50 million, the amount of losses. So very similar to the approach that GDPR had in terms of calculating, the fines and the impacts there. So that's already happened. But now what we are seeing also is consultations related to small and medium businesses, whether the exemption for small businesses might go away, which means that that they all are on the hook. And we know that some of these organizations, are challenged financially, but they still hold vast amounts of data. So it's a tricky, tricky problem. And I did a whole, actually, to the audience, there's an episode I did with Brett Randell just on small and medium enterprises and not-for-profits and cybersecurity there, because it's an area which requires attention all by itself. It's a very different world than the big corporates where, the silos may have larger teams, larger budgets. These organizations largely rely on managed IT providers and may not have a lot of support in-house. And managed IT providers may or may not be cyber experts. So it's a whole different conversation there. But the question back to you is, where do you see the privacy landscape changing, and what does it mean for small and medium enterprises?
Yeah, look, I think it's obvious we've got the changes to the Privacy Act. Well, we don't have any changes yet, but we've got a government response to the Privacy Act review report. And I think the next stage of that will be some draft legislation. But in my personal opinion, I would say that the space is still very much an emerging space, even immature, I think, in comparison to other areas and other jurisdictions. But as we, spoke about at the start, the general consensus is that the public cares, and there's nothing greater than the power of the people to get things to change. Changes coming through, yes, there will be a tightening of regulation, but I think that there's going to be some toing and froing. It's not as simple as just going or saying to small and medium enterprise, okay, the exemption's out, too bad, you now have to, you're having to respond now to the APPs under the Privacy Act. It's simply impossible to just sweep that away immediately. So based on the government response, they've agreed in principle that the exemption probably does need to go. However, they're going to engage, I think, with small and medium enterprise and better understand what that looks like. I think there's going to have to be some financial assistance because it is incredibly expensive. But the flip side of that is that, as you said, small and medium enterprise hold a lot of information. They are custodians for huge amounts of data, and in the chain, often they are at that third and fourth party supply chain. And we do see more and more that that's where breaches are occurring and filtering through to the larger organizations. Now, whether or not it becomes an obligation on those larger organizations to provide assistance to the small and medium enterprise, who knows? But I do think that, there's going to have to be changes in the landscape. And one of my bugbears in particular with the current regime is that employee records are excluded from the Privacy Act. Now, every organization holds vast amounts of information on their employees, and the idea that, I have no right even to apply, for example, to the Office of the Australian Information Commissioner because of, poorly handled employee information and then a breach, sits uncomfortably with me, to be honest. And so one of the recommendations in that report, in the government response, is that also that exemption is removed, and I'm quite for that.
No, that's obviously right. I mean, that impacts such a large amount of population, and And it's a key bit as far as I'm concerned with regards to how we think of this strategically. Because if you look at the Australian cyber strategy, the new cyber strategy that came out from 2023 2030, that places a lot of focus on small businesses as well. Cyber health checks and providing assistance to them and advice to them. That's good. It's a positive step, but we know the sheer volume of organizations we're talking about and the volume of data that they have is going to require, multi-year educational effort, multi-year, capability effort, and also helping them navigate this mess, right? Like I think for a lot of businesses, they're trying to just do the jobs and survive and serve who they want to serve. This is not on top of their minds as much as we want it to be. But I think that's where crystallizing the message, giving them simple tips, but also I'm glad that the government's at least, in the phase of consultations, and I hope that is well thought out to your point, uh, and also covers these blind spots. Because I recently, I'm not sure you've been following this, but OAIC did take some action against Australian clinical labs about the breach that they suffered, and the timeliness of the notifications and the response there was called out as a problem area. Uh, so that means OAIC to me is like there is that desire now to your point, respond to the community expectations and be more aggressive. And we've seen other regulators kind of been doing this for a while, but this was very interesting to me. Any comments, by the way, on OAIC action? And then do you think that we're going to see a lot more of these, by the way, from
Yeah,
OAIC?
so look, I was very interested to see about the Australian clinical labs. One of the main arguments, as I understand, and I hope I'm thinking of the right one, so the OAIC have commenced proceedings in the federal court, and they've released their concise statement, which outlines, the causes of action effectively or the relief that they're seeking against ACL. And one of the breaches in particular was of interest to me in that they did take too long to notify the OAIC or any of the regulators of what had occurred. They were very slow to get off the mark. They didn't really know what had happened, and their procedures and policies in place just weren't activated. They weren't up to scratch. And in fact, their whole cyber, given that they are such a large organization, they're listed, they've got a lot of money, their cyber package internally, financials, was very low. I think it was $350,000 spend a year. When you're talking an organization of that level, it's not good enough. So look, that was fascinating, and I think that the OAIC are trying to move towards commencing more proceedings. They are doing a lot of their own investigations. However, I think that they've sort of gone from 0 to 100 really quickly, and they've been inundated, and I expect that it would be really challenging to investigate every single matter that comes across their desk. It's very involved, it's taxing, takes a long time. You're trying to get disclosures and documents from organizations, and it's hard work, and it does take, a really long time. So I feel for them in that regard. So I think we're going to see more and more of these proceedings by the OAIC in a similar vein that we see with ASIC and APRA commencing proceedings against other companies. So yeah, I think watch this space.
No, it's and definitely, I think again goes back to the preparation bit. And look, all of these conversations we've been having, and just to throw one more, by the way, is St. Vincent Health. So one of the Australia's largest provider for or not for profits, rather for aged care. They can potentially, and this is what Home Affairs has said, right, is because they're considered as critical infrastructure, the breach that they suffered, that could potentially be a problem for them from that angle if the risk management programs are not adequate. So it's an expectation, to your point, across the patch. Like APRA, ASIC, they've been doing this for a while now. Now we're starting to see other regulators and this Home Affairs regime like coming forward and taking action. So all of this now, right, as an organization, firstly, let's put ourselves in a position of a small to medium enterprise. For them, I do think they really need to get strong cyber and legal expertise if they don't have it in house. Get a virtual CISO, get a cyber lawyer to be on a retainer or help you, because I think you cannot, I can't emphasize enough, rely on just managed IT providers to do this for you. Like you need to apply the strategic insight on this. But let's just take, even not just small and medium enterprise, like broadly speaking, defensible cyber programs. Uh, Georgia, from your perspective, all the challenges we've seen, right? Timely notification of incidents, legal professional privilege, breach response, adequate security practices, investments, all of these things are leading to this point of what should people consider when it comes to defensible cyber programs. Give me your thoughts, and then I'll share some of mine.
Yeah, and look, I think it's daunting. It's this huge kind of worms that you open and you don't know where to start. So I feel for organizations at all levels, really. I might carve out the big multinationals and super large, but it's where to begin. And I think understanding what you're trying to protect, understanding your own internal business context, your organizational context as a whole is probably the first thing. What do you do? What are your crown jewels? What are you trying to protect? And then work backwards from there. So if you are, if you have a heavy amount of consumer information, okay, you need to protect that. So let's talk about it. What do you collect? Where do you store it? What do you do with it? What happens when you don't need it anymore? Are you giving it to other people? Simple things like that, just starting with an understanding and an exploration of what's most important to you and then what you do with it, I think is great. I think organizations have a tendency to throw a technology at the problem, and if you don't know how to use it, if you are not willing to invest the time and resources to ensure that that technology is doing what it is doing and operating at its fullest potential, I would hazard against it. It's people, process, and technology. You have to understand your people, you have to understand your organization, you have to understand and, really upskill your employees to understand why cyber, why privacy is an issue and what they can do holistically to become better informed and to really build that resilience. And then from there, you build in processes, procedures, policies, and you educate your staff on those policies and procedures. And not just here's another policy, you need to have this information security management system policy ticked on your employment hero or whatever. It's you actually have to explain it to them. People aren't silly. Your staff, your employees care. So give them the benefit of the doubt and sit down and explain why they need to do, X training or why this is an important policy to understand at its core. Because that information is power. If you know what your obligations are as an employee and why you can't leave your laptop in your office at night, that's helpful. And just those little baby steps just really, really help to build your resilience. And then, you can move on and you can grow your, get your CISO as a service, which is, I think, awesome. Build that out, build out the capability. But, it's actually quite simple. You can do it relatively inexpensively as well. But you just got to know where to begin.
No, definitely. And I think it all starts to your point is right, the visibility. So I always think of defensible cyber postures. There are a few things come to mind, right? One is accountabilities, making sure that that is well established in the organization, that is actually, the executives, the boards, the senior leadership's involved. It's not just an IT problem. You have visibility to your point. It comes back to understanding your business, understanding the assets that matter, understanding the threats that are relevant to you. Not every threat is relevant to every organization. I think that's really key. You need to have the right measurements to your point. We need to have the right metrics and, be able to articulate those metrics smartly. If you don't, the old adage, right, is you can only manage what you can measure. So you really need to get those measurements right. I think the also other part I like to emphasize, which is really key, and you brought this up, is culture. You need the right culture, and that means getting people to truly understand what they're responsible for, why they're responsible for. And it's not just saying security is important, but actually living and breathing it, right? I mean, that's where culture comes in and moving beyond the traditional checkbox compliance training type activities. It's not a one-time training. It's actually relevant to your day-to-day jobs and also decisions that we make, right? uh, strategically pausing on a product feature because there is security deficiency, or rushing to the market acknowledging the risk of it. I think it comes back to what the culture of the organization is. Are people willing to speak about the weaknesses that they see? Are they open to sharing incidents or mistakes that they have made, as opposed to, hiding them, fearing, adverse consequences? I think it all comes down to these different areas to me. So I think and to your point of, it takes time, right? It takes time to do that initial assessment of what are we really protecting? Where is all this information? But if you have that, and if you have at least a decent handle on it, and you understand it, I think then you can put so many controls. And you're right, it's not a tools issue. Absolutely, if when people throw tools at a problem, that's when you're not solving the problem, and you're spending a lot of money that is, typically wasted. And we've seen that, and I've actually talked about it in my books as well, where I talk about, build a business aligned mindset, have good enterprise security architecture, think of cybersecurity risk management exercise, because that's all it is. There is not a right, there is not a wrong. Typically, it's all about the risk that you're doing, and are you informed in that engagement. So, it's and hopefully that will help. But also, I think more and more organizations need to think about the resilience aspect. And this is where it's these tabletops, the preparation, the incident response, the rehearsing, building a muscle memory. You'll never truly be prepared, because everything is going to throw a different wrench in the works. But you can at least be, by and large, have a strong way of responding to it, have the right people, have the right processes, and cover your bases. To our point, we talked about the legal professional privilege, ransomware positions, how you can pay ransom, not pay ransom. It's a whole different area. But if you haven't thought about it in the heat of the incident, it's a really terrible time to do anything. So hopefully that gives our audience some food for thought on all these different issues. Georgia, you've been awesome and generous with your time, and I think we've covered so much ground. And I think we need to do a part two of this as well, as we see some progress on these lawsuits. But are there any closing thoughts that you want to share with the audience before we formally close the episode?
Oh, look, the only thing I would say just on the class action space, Optus have actually appealed the decision with respect to the legal professional privilege point, and the court has indicated a willingness to look at those particular parts that are probably actually privileged, actual legal advice with respect to, and you can carve it out, right? You redact it. That's all it is. It's quite simple. It's a bit of a nightmare being the person having to do the redacting, but once you get there, it's fine. And I would just say also there's a push and pull between the disclosure of those types of documents. It is critical, sensitive business information. It is a security risk in itself. Having a document or a whole report detailing your cyber strategy, what occurs on a technological basis in your organization. So I can appreciate both sides of the coin there. But I think in terms of openness and transparency and ensuring that these sorts of things are mitigated going forward, I do think it is important that people understand what went wrong. But yeah, that's just a little tidbit on that, because I can appreciate both sides of that fence.
Yeah, look, these things, to your point, are never straightforward, and this is why I think you need expertise. And I do believe that I understand the challenges that especially the small and medium organizations face, but I believe this is an investment that they can make with the right advice by their side, so that they protect themselves against problems in the future. And not just small and medium enterprise, every organization. I think and I talk about this when I talk to boards and executives, is the questions they should be asking their cyber team. So switching the hat here, it's you got to get these answers, right? That, are we looking at the right risk? Do we have the right investment profile? Have we considered the emerging threats? How are we going to do the response? Because when you put that on, you're actually looking at things more holistically, and you are not just doing a checkbox of, oh, fine, a CISO presented to us this quarter, and we've looked at whatever, and we heard him or her and move on. I think there is more to it than that, and I think this is where they're asking the right questions is going to become the key to the game. So hopefully we have more engagement and more education in the space, and we have true expertise kind of shining in this area, as opposed to a lot of noise that we typically see. So it's really key. But with that, Georgia, thank you again massively for the time, the insights that you shared. I know we'll be continuing our conversation as this field evolves rapidly. And to our audience, thank you so much for tuning in and supporting us. If you like what we do, please subscribe to the channel. It always helps us and gets great guests to our show. So with that, thank you and have a great Happy New Year.